All right, welcome everyone. Today we are honored to be joined by Heather Meeker. Heather Meeker is um, she's a venture capitalist, intellectual property lawyer. She was trained at Yale for undergrad and then UC Berkeley for the law degree. The JD is for UC Berkeley. She's been a TED Talk speaker as well as an author. Your latest book is Open Source for Business.
Yeah,
And
my latest book is actually From Project to Profit. It's more of a
oh, it's a
business
newer
book
book. Okay.
than a law book. But yeah, Open Source for Business is probably the best known one.
Okay. And she has a list of awards that's like way too long to list, but relevantly, she was IT Lawyer of the Year in 2018 and had some very prestigious award called the IP Vanguard Award for intellectual property lawyers. But anyway, I think we are in the presence of greatness here. So thank you so much, Heather, for joining us and kind of lending us your expertise. This is something that I'm sure. So you've never heard of Aptera before until I contacted you. Is that correct?
That is correct. I was not aware of it.
Okay. And so this is but you kind of looked into it a little bit. It's a startup um, electric car company that has a fairly rabid following. We're a very small but pretty interested community here. And this lawsuit, this pending lawsuit, I guess, kind of was news to us because we just found out about it like 4 or 5 days ago in this SEC filing, and everyone's like, "Oh my goodness, the company's doomed! Like, what does this mean?" And then there was a lot of, internet lawyers who aren't lawyers but knew a little something, and they were
Yeah, I'm
pontificating.
familiar with that.
Yeah, they're pontificating on what they feel like it means. So I thought, well, maybe if I can find an actual intellectual property lawyer that has some actual expertise, maybe we can get a little bit more clarity on the situation. So thank you for that.
Oh, my pleasure.
Okay, so can you explain to us what this lawsuit is? And I'll pull up the complaint and share the screen while we get started.
Yeah, so the first thing to keep in mind about any lawsuit is that when you read the complaint, you're reading the plaintiff's version of the facts. So they file a document with the court that says, here's what we think happened, and here's why it's not lawful, and so here's the remedy that we demand. And then as the lawsuit progresses, the defendant gets a chance to answer the complaint and develop their version of the facts and so forth. So when we talk about what the facts are in this complaint, we're talking about the plaintiff's version of the facts, and they may be right, they may be wrong, they may be misleading, they may be spot on. You don't know until the lawsuit gets much further down the line.
Right.
But the complaint is essentially a patent infringement claim. There are other claims that are brought in the complaint, like trade secrets, interference with contract, unjust enrichment, and so forth. But the complaint spends most of the time talking about the patent infringement claim. And I think that's probably going to be the core of the dispute. It's very common for plaintiffs to throw in multiple claims in a lawsuit because if they don't throw the claim in at the beginning, they might not have as the facts develop, they might not have the chance to throw them in later. So there's kind of a tendency to cast a broad net at the beginning. And then as the lawsuit goes forward, the judge may eliminate some of the claims. I think based on the way this is written, this is mostly going to be about patent infringement. One thing to keep in mind about patent infringement, a lot of people struggle with this concept, is that a patent is a right to exclude. And so if I have a patent on something, that means I can prevent someone else from doing something, and that something is usually make, use, sell, or import a product. It doesn't mean that I am able to produce any product at all. I don't have to have a product. All I have is this negative right to
Mhm.
prevent people from doing something else. And so that leads to something that some people call patent trolling. The less pejorative name for
Mhm.
it is a non-practicing entity. And that may be what this plaintiff is. I don't actually know.
Mhm.
But it doesn't mean that the plaintiff has to have a product. It means that, at least as far as the complaint says, the defendant has a product that infringes the patent. And so the plaintiff can claim damages or ask for injunction, which means the court ordering the company, the defendant, to stop infringing the patents.
I see. So yeah, I remember reading several years ago about these patent trolls, and I in that article it was in the setting of software startups, which I know that's kind
Yeah,
of your main area of expertise. And these are, from as I understand it, people that just have a portfolio of patents and they just go after startups that don't have much
yeah.
money to defend themselves at the point where they look like they might become successful and they can extract some monetary value from them. Is that still a problem now? Because I read about this like 8, 10 years ago. Is that still an ongoing issue?
Oh, it's a huge problem. And interestingly, many of the patents that are bought by the non-practicing entities, um, are bought out of bankruptcy
Mhm.
from technology companies.
Oh,
And that is kind of what happened here.
yeah.
So what happens is, a company will start up, they'll get a patent or two, they'll fail, and then those assets get sold off when the company fails. The buyer becomes a non-practicing entity and then goes and sues whoever they can sue. It's actually, I mean, there is some controversy about this, but I would say generally that it's a big problem and a drain on innovation. The law could be different. It could say, for instance, that you have to have products of your own in order to sue for patent infringement, but that's never what the law has said. So yeah, it's a really big problem. And I think it gets a lot of attention in the software industry, but it's potentially a problem in every sector.
Yeah. Okay, so it looks like based on their complaint that we're reading here that the Zaptera company got they bought this out of something called an assignment for the benefit of creditors.
Right. So an assignment for the benefit of creditors is similar to a bankruptcy proceeding. What most people think of as bankruptcy proceeding in the US is a federal court action. But there's a state equivalent called an assignment for benefit of creditors, which they've abbreviated ABC here. Um, they are a little less complicated to do, and so sometimes people go through an ABC instead of going through federal bankruptcy.
Hmm.
But it basically means that the debtor, the company, they can't pay their bills, they have to liquidate, and so they're assigning, meaning selling their rights in order to get some money for their creditors. That's why it's called an assignment for benefit of creditors.
I see. And so the two patents that are involved in this are these two patents right here, the
Right.
aerodynamic vehicle body and aerodynamic vehicle. Is that correct?
That's right. And the very interesting thing, one very interesting thing about this case is that these are design patents. So what most people think of as patents are the other category of patents, which is called a utility patent. So if you come up with an idea for a better mousetrap, great semiconductor design, even some software that has an interesting method of doing something, those are utility patents, and those are based on what the product does. A design patent is basically dependent on how the product looks. So this is very different from what most people think of as patents. And in fact, even lawyers who work in the patent area probably don't come across design patents all that often. They do, but it's much less common than a utility patent. And what that means is that when you ask, has the patent been infringed, the standards are quite different. So if you have a utility patent, and so let's say I've invented a better mousetrap and somebody else comes out with a mousetrap and I go, okay, that new mousetrap the other person did, it looks like it practices the inventions that are in my patent. Then we ask questions like, how does the product work? And is that the same as the invention that is claimed in the patent? And we would usually get an expert to testify, an expert in mousetraps, right? Somebody who is, as they say, skilled in the art to testify about it, and then you come to a decision about it. For a design patent, the standard is quite different. It's from the point of view of the ordinary observer. So it's not so much the purview of experts, it's more the purview of just an average person looking at one product and saying, hey, that looks like this design over there. So it's a different world. Also, design patents have a shorter term. So their term today is 15 years. When these patents were prosecuted, it was 14 years. And utility patents have a longer term, 20 years, or sometimes a little bit more, depending on how things play out. So it's in that respect, it's quite different from most patent lawsuits.
I see. Is the reason that they're less common because they have less value in that they're harder to defend or harder to use, or is it because they're harder to get?
Well, I would say they're probably not harder to get, but the main thing that people use in order to defend things about the way a product looks is what we call trade dress. So there's a whole body of law, trademark law, that has to do with the source or origin of goods. So if I have a product and the design of it suggests that it comes from me, and the example people always give is like the Coke bottle with the like wavy shape and everything.
Mm-hmm.
Then I can prevent other people from selling those products on the basis of trade dress. And that's probably easier because I don't have to go and I can file a trademark, a trade dress application much more easily.
Mm-hmm.
And patent prosecution is pretty expensive. So there's this overlap between these two areas.
Mm-hmm.
And so I would say you see fewer design patents because there's another body of law that often deals with these issues.
Right. But with trade dress, from the way you're explaining it, it sounds like to me that like you would have to be a company that's fairly well known and
Yeah, there wouldn't
and
be
you
a
have to be
trolling
producing the
aspect.
product. Yeah.
Yeah. And also the design has to be evocative of a certain source.
Mm-hmm.
And just one second, I have to turn off my phone. Sorry, it went off.
Okay, no problem.
A moment. Um, so yeah, if you're right, if you have trade dress, that means you're protecting your own products, and so there's not this trolling aspect to it.
Mm-hmm.
Also, the way the product looks has to be evocative of a particular source for the product, and that's not true with design patents. It's just, do they look the same? The ordinary observer doesn't have to think, oh, this design is associated with this specific source. So it is a little bit different, but
So,
they do overlap in quite a few respects.
right. Now, like, can you patent something that's very common in the public sphere? Like, could I patent a sphere or something like a spherical shaped vehicle or something like that?
Probably not.
Uh-huh.
In any kind of patent, you have this notion called prior art, which is what has everybody done before you?
Mhm.
And by the way, in patent law, they use the term art to mean more like engineering, right? So
Okay. Okay.
it doesn't mean artistic necessarily.
Uh-huh.
But there is this notion of prior art. So when you file a patent, you have to actually disclose anything that has come before that you have based your patent on.
Mhm.
And so something like a sphere, it would probably be too common and the patent office would probably reject it. Now, I don't know if, I haven't seen any vehicles that are spheres other
Right.
than those balloons you roll down the hill in.
Yeah.
So maybe if it really were a vehicle that were a sphere, I don't know, but if you tried to patent, say, something that looked like
A
a
sedan.
long, narrow Formula One car, right?
Uh,
It probably wouldn't work because that's basically too common. But the question of prior art and what we call non-obviousness
mhm.
in patent law is it can be very complicated. So yeah, there can be this notion that the patent shouldn't issue because it's not new enough, the idea or the design isn't new enough.
Right. Like, in our previous discussion, I sent you some pictures of things that look similar to this. Okay, well, I think we should maybe go down to the pictures in this complaint. Okay, yeah, so here we go.
Yeah, these are very interesting to look at. The plaintiff has put side by side
Right.
the designs from the patents and the current, I guess, the Aptera vehicle that I don't remember exactly what the status of that is. Maybe it's in the design stage.
Yeah, they're
Maybe
in the stage where they finished design and they're trying to make the testing vehicles to validate the vehicle, basically. And so this
right.
design has now been finalized essentially. And they have these side-by-side pictures, which do look similar.
They do look similar. And then the big question here, I think, is how much of that similarity is functional? So utility patents protect function. Design patents do not protect function.
Hmm.
So, never the twain shall meet, right?
Okay.
So anything that about the design that is functional in nature would not be protected. And you can imagine,
Hmm.
I mean, these are being called aerodynamic designs, right?
Yes,
So anything about them that is necessarily the way it is because of aerodynamics, that would be more of a functional aspect to it and might not be protected by the design. So that's where the complexity is going to come in here. Like how much of this is driven by function and how much of it is like the artistic or aesthetic nature of the design.
I see. So if Aptera, the company, states or makes the case that their vehicle looks like this because of function, then that can be used as a defense against this design patent.
It might. Now,
Mhm.
this is where this case might get a little complicated because there is this notion in patent law that called Assignor estoppel. Okay, so
Okay.
then we have to talk a little bit about what happened in this case.
Okay, yeah.
So, sorry to derail you a
No,
little,
no, no.
but what happened, at least according to the complaint,
Mhm.
is that the original iteration of the Aptera company, which I think was Aptera Inc.
Yes.
Um, it closed down. It did an assignment of benefit of creditors, and it sold its patents to apparently the plaintiffs. I
Mhm.
think there's some lack of clarity about that, but
Right. There's some
that
dispute about that, possibly.
yeah,
Uh-huh.
but that's what the complaint says, right?
Mhm.
So the plaintiffs buy these patents from the old Aptera company, and then Aptera of today is a new company that was set up to succeed the old one.
Yes.
Now, the problem is that there's this notion of a sign or estoppel, and here's what it is. If I sell you a patent and then you sue me for infringement based on that patent, I can't claim the patent is invalid, or I might
Oh,
have significant limitations on what I can do there because I took the position that the patent was valid when I sold it to you.
I see.
Now, this case is way more complicated because it's not the same entity, it is some of the same people. And you may have noticed that the complaint actually it purports to sue individuals as well as the company. And I'm maybe reading between the lines that might be because they want to prepare for an assign or estoppel argument, because the people who are actually being sued are some of the inventors on the patent.
Right.
So as an inventor or owner of the patent, you have trouble claiming that the patent is invalid because you once basically said to the government, right?
Uh-huh.
And then again to the person you sold it to,
Uh-huh.
this is IP that I own and it's valid.
Okay.
So the defendant here might have more trouble than most defendants would have claiming that the patent is invalid.
Okay. But by making the shape a functional, is that you're saying that that's an argument that the patent is invalid?
Uh, Maybe not, right?
Okay.
So now we're getting pretty granular.
Okay.
And I'm not sure how it would sort itself out, but these are just the principles that would drive the case going forward.
Got it. Got it. Okay. Because this is a picture of one of these like solar races.
Uh-huh.
They had the MIT team had this thing called an Aztec back several years ago, which also looks very similar to here we go. Let me scroll down to it. Hopefully I'm going to find it. Yeah. Oh, it looks very similar to this Aptera vehicle. And
Yeah, and I think the reason it looks similar, by the way, I mean, to me, I'm just a layperson, right?
Sure. Uh-huh.
Is the aerodynamic aspect of it, like
Absolutely.
that shape it's basically like the shape of an airplane wing, right?
Yeah.
And so, yeah,
Yeah, it
so
comes from this guy. He was a professor at Turin University. He did a bunch of research on what the most aerodynamic shape of a
uh-huh,
thing that's close to the ground is, because the ground causes some aerodynamic changes that are different than high up in the air. And
right.
he called this the Morelli shape. And as you can see, this shape and this shape and
They
this
look very
shape
similar to
are
me.
essentially that's the shape.
Yeah.
So, but because this was granted, they're gonna have a hard time saying that, oh, well, this is just a common shape that everyone knows about.
Well, it's certainly, they'll have to be careful about how they make their arguments. I'm sure they can still make some functionality arguments, but, they, they can't claim but the patent doesn't claim anything functional, okay, so,
Yeah,
they can't, what they would have trouble arguing is that what is claimed in the patent is not valid. So there's probably some wiggle room in there.
I see. Okay, the one thing that you brought up that was sort of interesting is you said that the the time frame for these design patents was 14 years, and these were um granted April and March of 2021. So these would expire in by April of 2025, correct?
Yeah, so I think let's see. It says here the term is 14 years, so it was at the time that this patent was filed for a
Uh-huh.
design patent, and the issue date is 2011. So yeah, they would be very close to expiration. In fact, it's not that uncommon for plaintiffs to sue right before the expiration of patents.
Yeah,
The reason probably being that that's the time when there'll be the most damages. Like the later you sue, the more damages there are going to be.
I see.
So, yeah, so they are, I wouldn't say they're on the eve of expiration, but they're getting to be, I guess, within a year or so of it.
Yeah. So what kind of damages can they sue for? Because this company has not sold a product yet. And it seems unlikely at this point that they're going to sell a product before April of 2025.
Well, of course, if the company had sold products, it would be a more interesting damages argument.
Yeah.
But I mean, I don't know what damages arguments the plaintiff is going to make, but
Mhm.
they might claim that the value of the company is part of the damages or something like that. You know, they've raised some money, I guess.
Yes.
And the value of damages for patent infringement, the core thing is what we call a reasonable royalty.
Okay.
And so that's kind of market driven, and obviously there might not be a very useful set of market comparables for this.
Yes.
So there would be a lot of argument about what the damages are in a case like this, and it would go back and forth, and you know, the defendants would say it's zero and the plaintiffs would say it's $1 zillion. That's just the way it always works.
Right. But the fact that they haven't actually sold anything does not protect them necessarily. There are other damages.
No, because a patent governs the right to make, use, and sell and import. But you don't have to have sold a product in order to be infringing of a patent.
I see. Okay. And then this was the other thing that came up is, so I'm gonna look at, this is the letter that they sent on July 28th, 2022 to Aptera. And they basically told them, hey, you guys are infringing. Okay, this is my understanding of the letter after reading it. They said, hey, you're infringing on our patent. You need to contact us so we can talk about you giving us royalties or something.
Right.
And then Aptera responds to them with this letter, which basically says, from what I understand, don't talk to us. You haven't proven that you even own this thing. So until you can prove to us that you even own this thing, because as far as we understand, Idea Labs owns this thing and you have no standing here. So just stop talking to us. Is that a correct assessment, or?
That's what it looks like on face to me. So the first letter, which is sort of a demand letter or, you know, an invitation to negotiate, that's totally normal in patent infringement, you know, process.
Yeah.
Right? It is a typical pre-litigation letter.
Yeah.
The response is unusual.
Okay.
And it seems to be saying that the lawyer who represents Aptera doesn't believe that the plaintiffs really own the patents, and that's not something you see every day. He also is saying that Zaptera USA Inc. is not licensed to do business, meaning perhaps the corporate filing expired or something like that, and so. And of course, the complaint doesn't really say much about this, right? Because this would be the defendant's facts.
Right.
So yeah, I was interested in that too, and that was sort of the footprint of possibly a huge factual dispute in this case.
Right. So this kind of, we get an idea of how they're planning on defending this, I guess, maybe.
Well, this is just one thing. They probably have lots of other ideas about how to defend it, but so they might be saying, you don't really own these patents, so you can't assert them. They might be saying, even if you assert them, we don't infringe. They might say, even if it infringes, there should be no damages. There would be many different arguments.
Right, many layers of defense on this. Yeah, because in here, you know, they give them this exhibit that claims that Idea Labs owns it. Now, I guess it could be that this was recorded in July of 2021. Maybe this is before it was sold off in the assignment of
it's really hard to tell what's actually going on there with the assignment.
Right.
By the way, Idea Lab is a company that was very interesting. It developed a whole lot of stuff during the internet boom, and so it's interesting that they bought or purportedly bought these, because they mostly did web stuff at the time, at least.
I think in the initial iteration of Aptera back 15 years ago, like Google and Idea Labs, there were some incubators that invested in them, and I don't know if them being assigned the patent was part of that or not. I'm not sure
Well, they
what that
might have
is.
been a creditor for the company.
Yeah,
I don't know.
I
But
see. Yeah,
if so, then it would make sense that they might have gotten some of the patents in the assignment for benefit of creditors.
I
That
see.
there's not too much in the complaint. Oh, there's not enough in the complaint about that to figure out what exactly went on.
Right. And then this is the other exhibit where they show that they're saying Zaptera is suspended and not a functional entity, it looks
Yeah,
like.
that happens a lot to companies that don't do a lot of business. It's actually quite easy for it to happen. You can often revive a company once it's lapsed, but I don't know offhand all the circumstances in which you can do that.
Uh-huh. And so then this document date is more recent than that, and they're saying that in this one the assignee is Zaptera.
Yeah,
So
so it's
that's
possible the patents were sold on to someone else.
right. So I know this is like not legal advice, and you're not you just like have very limited information, but can you tell us like what you think may happen in this case? Or is that just
Well, what usually
uh-huh,
happens in patent cases is that you end up paying some royalties.
uh-huh,
I mean, um, most patent cases, in fact, most lawsuits never go to trial.
uh-huh,
What happens is a complaint is filed, there's maybe an answer, the parties start negotiating a settlement, and um, the important thing to understand about patent lawsuits is that they're about money.
mhm.
And so you dispose of them with money.
I see.
So, maybe they would negotiate a settlement, maybe they would pay some money, maybe they would pay some equity. You never know. You can negotiate anything you like in order to settle out the lawsuit.
Mhm,
Um, It's also possible, for instance, if there's a problem with the chain of title of the patents, that the defendant could say, no, we're not negotiating, you guys don't have the right to do this, and it's possible that the complaint could be dismissed. But
I
if the
see.
complaint isn't dismissed, there would probably eventually be a settlement.
Okay.
By the way, it takes quite a while for lawsuits to actually go to trial, so there's plenty of runway to do a settlement before that happens. And also, the fact that a lawsuit has been filed doesn't mean a company's dead or anything like that. It's usually not as bad as people think when the
Mhm,
lawsuit is filed. In fact, I had a friend a long time ago who said he wanted to set up an investment fund that only bought stock in companies when there was an announcement of a lawsuit and the stock price dropped, because it always ended up better than people thought. But I don't know if you ever actually tested that investment thesis, but I think there is some wisdom to that it looks very bad at the beginning, but that's because what you're seeing is the plaintiff's version of facts.
I see. So, in your experience, in most of these cases where what's the more benign word for patent trolls
The
again?
non-practicing entity.
Non-practicing entities, in the vast majority of them end up with some kind of monetary settlement.
They do, and there are in the law, in IP law,
Mhm.
uh, we lawyers think about non-practicing entities in kind of different buckets, and
Okay.
there are like the ankle biters, and then
Uh-huh.
there are like the very serious ones, and maybe somewhere in the middle.
Uh-huh.
I don't know if this Zaptera, or maybe the people who own it,
Uh-huh.
how much track record they have suing. Like
Uh-huh.
when you're defending patent suits, the
Uh-huh.
first thing you usually do is look up the plaintiff and see if they've sued anyone else successfully,
I see.
because there are some such entities that have a business model of just trying to get small settlements.
Uh-huh.
Uh, uh, they don't usually file lawsuits, by the way. They usually just send those letters,
Uh-huh.
like the one in the complaint,
Uh-huh.
because they don't want to go to the expense of filing a lawsuit. But
Uh-huh.
different non-practicing entities have different business models, and some of them are very much like send out a whole bunch of claims and see who bites and get small settlements. And some of them really go to court and get big settlements. So I don't know anything about this plaintiff, and so, but a lawyer who was defending this case, the first thing they would do is do some research on the plaintiff.
I see. But most of them do end up with some settlement, whether it be small or large.
Yeah,
Uh-huh.
that very much so. I don't know what the percentage of patent lawsuits that actually goes to trial is, but it's certainly very low.
Okay. All right. Anything else that you would like to comment on this or in any other?
Well, as an intellectual property lawyer, it's always a little sad to see the person who is the inventor or the author of something gets sued for something that they actually created. As you
Right.
can see, the inventors here are
Yeah, Jason Hill,
some of the
he's with the company.
defendants in
Yeah.
the case,
Yeah.
right?
Yep.
And that's a little sad, right?
Uh-huh.
It's like one of the weirdnesses of IP law that you can sell off the rights. And I think I mentioned to you when we corresponded, like it's like the John Fogerty thing, like getting sued based on songs he actually wrote.
Right.
That
Your new
I
song
don't.
sounds too much like your old song.
Yeah, exactly.
But I'm
That's
like,
kind of
it's my song. They're both
sad.
my song. Yeah.
Yeah, it's kind of sad, but it does happen sometimes. So that's a little unusual, and this is, maybe we step back and question, okay, like, should this be able to happen in IP law? But it definitely can happen, because people have the right to sell their IP to others. So, that's a little sad, but it'll be very interesting to see how it plays out, because it is an unusual suit in that respect, and the design patent thing, and so, and the question about who really might own the patents. So yeah,
Right.
interesting case.
Yeah. Okay, so before we wrap up, I kind of wanted to ask you to change your hats a little bit, and I want to ask you a general question because you've had your lawyer hat on now. You're also a venture capitalist, and Aptera is a company that is a startup company that has been looking for venture capital funding and have been moderately successful at it. They've gotten
Uh,
most of their funding through crowdfunding, and they have not found a large venture capital firm. They've found some small VC firms. Basically, as a venture capitalist, when you're looking at a startup company, what are the things you look for before you guys decide to invest?
oh, so, well, first of all, my investments are only in open source developers. So that's a very narrow thesis, and that's unusual for VC.
Uh-huh.
So, like that's the first thing I look for. But laying that aside, if I
Yeah,
were doing something more general, the traditional wisdom is that you look at a few things. You look at the technology, right? You want to assess how good the technology is, how likely it is to be, capable of making a commercial product. You look at the market, so you look at how likely it is that there will be an actual market for the products. Like, even if it's the best product in the world, if there's no market for it, then it doesn't matter. And
right.
you look at the team, so
Uh-huh.
it's like tech,
Uh-huh.
market, team, that
Those are,
almost all VCs look at.
mhm,
And so they're going to want to find a team that has some experience doing startups. Maybe
mhm,
a successful exit before is nice to see.
mhm.
As far as the technology goes, I would say, being realistic, that's a little bit harder for most of the VCs to assess. They sometimes have technical experts come in and do diligence on a product. Um, but market is probably what they focus on the most.
I
Like,
see.
VCs are, for the most part, they're in it to make money. And so they want to invest in something where there's a big untapped market, so that the startup can be maybe a first market mover, or dominate the market somehow. That's what
I
they're
see.
looking for. And I'll also add that the past few years have been really rough for raising money
Yeah.
for startups. And so it's not surprising to hear that more companies are doing things like crowdfunding. A lot of the VC money kind of pulled back,
Mhm.
and that's because economics, right? You could get, what, like 5-7% in T-bills,
Mhm.
right, over the last few years. And so then it starts making less sense to do highly risky investments to get high returns. So a lot of the money got it kind of sucked back off of the table in VC. Now that things seem to be normalizing again, hopefully we'll see a little bit more venture funding, in the next few years. But it has been really tough unless your business was large language models.
Yeah.
You weren't getting, that was the conventional wisdom. You weren't getting funding within the last few years.
I see, I see. And so do venture capital firms, like, where's their source of funding? Do you guys have like a group of, high net worth individuals that are like, hey, you guys, here's our money and you guys use it? Or is it usually the people in the venture capital firm, it's their own money?
Well, it's a combination, although mostly the venture model is to get other people to
Uh-huh.
invest their money. The
Okay.
the the people who start funds are expected to invest some of their own money, but it's a small portion.
I see.
Um, but yeah, high net worth individuals, family offices, so people
Mhm.
with family trusts. In order to get into other kinds of money, which is like what is sometimes called institutional money, pension funds, other funds of funds and so forth,
Mhm.
you usually have to be above a certain level in how much money you have under management. So it really depends. There are venture funds that are relatively small, and there are ones that are huge,
Mhm.
and they go after different kinds of, they're called LPs, limited partners, investors, from smaller funds, which are mostly going after individuals and family offices. Um, the, there's a lot more process with going after institutional money.
Got it. All right. Well, Heather, thank you so much for sharing your time and your expertise with us. That was great.
Thanks. Can I do a plug for my channel?
Oh, absolutely, of course. Yeah.
Yeah,
So Heather
yeah.
has this is the way I found you actually. You started a YouTube channel, and I'm curious, why is someone as accomplished as you are starting a YouTube channel?
Well, it's mostly for fun,
Okay.
because I've written a lot and done a lot of presentations as a lawyer, and they're all fairly, serious, I guess. I have a bit of a humorous bent, but
Uh-huh.
mostly what you would expect with professional materials. But then, I have some YouTube channels I really love watching that are a
Hmm.
little more irreverent and have an odd take on things. And I thought, I can do that,
Yeah.
so I did something called Heather Thinks About Software, which is mostly when I see things in the news that I think are kind of ridiculous, and
Uh-huh.
then I try to run them down and figure out what's actually happening. And
Uh-huh.
I find with a lot of news stories about technology that a lot of the commentary is actually pretty inaccurate
Okay.
and
Yeah.
or misunderstands it. And
Uh-huh.
so I try to kind of pick it apart and say, this is what's really happening and so forth. And I usually cover topics like that have to do with software or copyright or technology.
Uh-huh.
So that's, uh, I hope they're amusing. They're mostly for amusement value. So if you
Uh-huh.
want something a little educational and in an amusing way, yeah, go check it out.
Yeah, I will put a link to that channel in the description below. Everyone, please check it out. And also you can also be found at heathermeeker.com as well, correct?
That's right. More information than you would ever want about me is at heathermeeker.com.
Okay. All right. Well, thank you so much, Heather. We will 100% put those links in the description below. So please
Great.
check that
Thanks.
out, everyone. And thank you again for joining us.
Well, thanks for bringing this to my attention, and it was really interesting. It's been delightful talking to you.
All right. Thank you.